goes to Zion Crossroads tomorrow to do again engage part 2 again, and then in the afternoon, I think he's doing buy side in the afternoon at Zion Crossroads tomorrow. So keep those things in mind. Grateful for him being here. He's amazing. Grateful for him wanting to be here on a regular basis. But we're talking about the contract. We're moving into paragraph 6. Thankfully, Jay is here joining us so that we can get his input in regards to the VA and the FHA loan. As we talked about, what's today, Tuesday, Thursday. One of the big differences between, well, there are a number of differences between the VA and FHA loan, but one of the big differences is conventional. There's nothing in paragraph 5 that talks about the appraisal. So as we talked last week, you need to add that in to either the other financing terms in paragraph 3 or the other terms in paragraph 34 or whatever that paragraph is. And basically that the property must appraise for the agreed upon contract price. But the other big difference with FHA is, well, FHA and VA is it does have, and as we read through this, you'll see it does have language as it relates to the appraisal. And as Jay pointed out last week, it can be a little bit stricter in regards to not only from a price standpoint, because oftentimes, obviously, VA is 100% financing. FHA could be as little as 3.5% financing, or I guess if they did VHDA, FHA, they could almost get no money down, right? Isn't there no money down? Yeah. So in those situations, you could have a stricter appraisal price, but you also have the FHA and VA appraisers have the ability to tell you that there are things you have to get fixed. And it can be as simple as a loose rail on a staircase, or it could be the roof. I mean, and once they ask for that to be done, not only does it have to be done, but you can't throw money at it. It has to be done, and the appraiser has to come back a second time and verify that gets done. So those are just a couple quick things, and I'll just kind of go through this, and then I'll turn the computer around so you can see Jay, and he can add his 2 cents worth, or in this situation 3.5% down worth. Joking. But VA and FHA loan is expressly agreed that notwithstanding, oh wait, let me share the screen, sorry. Here we go. So we're down at the bottom of page 3. Expressly agreed that notwithstanding any other provision of this contract, the purchaser shall not be obligated to complete the purchase of the property or incur any penalty by forfeiture of earnest money deposits or otherwise, unless the purchaser is given in accordance with the HUD, FHA, or VA requirements, a written statement by the Federal Housing Commissioner Department, blah, 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 direct endorsement lender. Direct endorsement lender, folks, you guys are all new enough in this business that you have no idea what it used to be like. With VA and FHA, it used to be that all these files had to be sent to DC, and the VA and FHA folks went through them, and it was an absolute nightmare. And so, how long ago was before you got in the business?
Yes.
So even before Jay got in the business, not before I got in the business, they created what's called direct endorsement. So Town Mortgage is a direct endorsement lender for FHA, VA. They can do all the underwriting for the properties, whereas back in the day, you couldn't do that. Files had to be sent to DC, and you just had no idea when they were going to come out. And then this is way too much more information you probably want, but the other thing that happened with VA is right now, VA interest rate is what, Jay? It's, basically in the range of a little under 3% VA. So, a veteran, being able to get 100% money for less than 3% is pretty amazing. Well, when I first got in the business, the VA rate was like 18.5%. And the crazy thing was, you might have a contract at 18.5% with the purchaser paying 1 point and the seller paying 1 point. And if that rate changed from 18.5 to 18, and it went from 1 loan discount point to 3, there was no lock. Somebody had to come up with that additional 2 discount points, which is equal to 1% of the loan amounts. To say it's a $300,000 house, that's $6,000 that all of a sudden nobody knew they were going to have to come up with from a buyer standpoint, or seller, had a situation where all of a sudden his equity could get dinged. So anyway, it was the wild, wild west back then, and absolutely crazy. So I'm just happy that it says direct endorsement lender now, setting forth the appraised value of the property, excluding closing costs, as not less than the purchase price. Purchasers shall have the privilege and option of proceeding with consummation of this contract without regard to the amount of the appraised value by giving seller written notice thereof within 3 days after receipt of notification of the appraised value. So what happens is you write a contract, it gets accepted. You get with Jay orders an appraisal. Appraisal comes in using 300,000 for a minute. Appraisal comes in at 290. The purchaser has 3 days from the time they get that notification to get to the seller and say, hey, we got a problem. We got a $300,000 contract price, but the appraisal's 290. Here's the other thing. I think it's true with VA as well, but I'll let Jay speak to that. With FHA, once an appraisal is ordered, it gets a number. It's an appraisal number. And if that thing comes in at 290, you can't just say, oh, well, I'm going to not use Jay anymore. I'm going to go to whoever and order another FHA appraisal. That thing, stays with you for how long?
I think it's 6 months,
Yeah.
but yeah, the FHA case number is attached to the property, not the borrower.
Right. So it stays in that situation for 6 months. So that's another, crazy thing. And then obviously it's important enough that they put it in all caps. The appraised valuation is arrived at to determine the maximum mortgage the Department of Housing and Urban Development Department of Veterans Affairs will ensure. HUD Department of Veteran Affairs does not warrant the value of the condition of the property. The purchaser should satisfy himself that the price and condition of the property are acceptable. So what that's saying is, purchaser, get a home inspection, do the things that you need to do, well and septic, termite, those kind of things. Get your agent to provide you the comparables so that you can determine what is a comparable price. Obviously, when the appraisal gets done, hope that it comes in at the contract price or above. These days, we are seeing some situations, 2 things. One, appraisal's taking longer because people are just so busy. And 2, we are seeing some appraisals coming in lower because what's happening is you have multiple contracts. You have what I call market trend value. And what I mean by that is, a neighborhood, the last house in the neighborhood sold for 300. The next house sells for 315. You get a 5% increase there. The next house sells for, 321 or something like that. And then somebody gets an offer of 330. You have a chance of getting it appraised at the 330 number. Based on the market trend. If an appraiser sees that things are trending upward, then somebody may not have closed anything at 330 yet, but the last 3 have trended percentage wise up. But it is, you always from a listing agent standpoint, you always want to tell the seller, don't exhale. We got a lot of things that still have to happen. We got to get through financing. We got to get through appraisal. We got to get through a home inspection. We got to get through well and septic, termite, all sorts of different things that still have to happen before we can feel comfortable that that the deal is going to close as it's supposed to. If purchasers obtaining a VA financing and elects to complete the purchase at a purchase price in excess of the appraised value as established by VA, purchaser will disclose the source of such funds to the department and pay the X amount from such source. Such funds will not be borrowed funds unless approved by the department. So again, what that's saying is 100% financing, 300,000. The contract, it goes for 315, and VA decides that it's only worth 310. So you got a $5,000 delta. That $5,000 delta, the purchaser has the right to make it up by paying an additional $5,000, but they have to verify where those funds are coming from. And unless they get the lender to approve it, they can't borrow it out of American Express or something like that. They may be able to if the lender will approve it, but it has to be by lender approval. And the other thing you definitely don't want to do is, and you wouldn't have to do in this situation, but have the seller pay that money, under the table to the buyer. Here, I'll give you $5,000 to complete this transaction. I mean, in this situation, you wouldn't do that. The seller would just say, okay, we're going to reduce to 310. But the point being is you can't get, or the realtor. That's probably even a better one. You can't do under the table things that the lender doesn't know, financing that can provide. So it's got to be approved by the department. And then C, if purchasers obtaining FHA financing, the parties acknowledge that the loan amount may be approximate because financed acquisition costs cannot be determined until settlement. And what that's talking about is FHA has, this, the MIP or PMI or whatever, and it's based on the loan amount and the number of days, and you're closing on the 25th versus the 30th. There are all sorts of different things. And so basically, what this is saying is that the parties acknowledge that the loan amount could adjust and be a little bit prior to closing, and so it's all approximate. And as we talked about last time, and then I'm going to turn the computer over to Jay here to talk a little bit about what we've just gone through and summarize. But loan fees, purchasers shall pay all points. Usually a purchaser is going to pay a loan origination fee. Loan origination fee, again, 1% of the loan amount. You don't really see points being paid. It used to be a real kind of standard operating procedure that an interest rate would be X, and it would be 2 points to the seller, 1 point to the buyer, whatever the case may be. You don't see a lot of that now, except for if you're in a situation, fortunate situation that the seller really wants to sell and hasn't been able to get their house sold. You might, offer with VA, you might offer for like 6% in closing costs and $300,000, that's $18,000. And maybe 3% of it is really closing costs. Well, you could use the additional 3% and get 3 loan discount points and lower that interest rate with that, because basically what you're doing is you're paying interest in upfront interest, which lowers the end of the day amount that needs to be paid, which increases the return on investment of lenders. So you can get a lower interest rate by those discount points. But purchasers shall pay all points, loan origination fees, charges, and other costs imposed by lender or otherwise incurred in connection with obtaining the loan or loan. The amount of any contribution seller agrees to make under this contract toward purchase loan fees shall include miscellaneous and tax service fees charged by lender for financing described in this contract, and which by regulation or law purchaser is not permitted to pay. So basically, as an example, seller's grantor's tax. That's a tax that every seller pays to the state based on their sales price. That's something that the seller is supposed to pay, not the purchaser. So Jay, I'm going to turn this to you. Let's see if I can find you on the screen here. I didn't want to go too fast to create seasickness. Kind of just give us a summary update. We talked about 5 last time, but into 6 and 7 in regards to just the personal experiences that you have.
All right, well, let me talk about 6 a little bit, because I've been making some notes on a couple things that you need to be aware of, or just reiterate. Okay, first of all, paragraph 6 is why it's important for you to check the appropriate box in paragraph 3.
Good point.
So if you don't check VA or FHA financing and that's what they're getting, then that's what triggers this paragraph to come into effect. So if I get a contract and paragraph 3 is not checked as VA and I'm doing a VA loan, then you're going to have to go around. You're going to create more work for yourself and the sellers and the buyers, because now they're going to all have to sign a separate form that says what this paragraph says. Okay, and some lenders will make you do their form anyway. So just keep that in mind. And just a general understanding what VA and FHA's role in all of this is VA and FHA aren't lending any money. Their job is just to insure the loan or guarantee the loan, in the case of VA, for the lender. So the lender has the authority to approve and close loans under FHA or VA guidelines. That's what Michael was talking about with the direct endorsement lender. That's just authority to do all this stuff. Now, if they follow all the guidelines, then FHA or VA will insure that loan. So you send it off to them. So that's why it's important that everything gets right when the lenders close the loan for FHA. Okay. The other thing to point out in paragraph 6, when we're talking about the appraised value, just because you put that clause in, this has become important as of late, is just because somebody is doing an FHA or a VA loan does not mean that you can't eliminate that paragraph and negotiate some sort of parameters as to what would happen in the event the appraisal comes in low. So it's spelled out here a little bit. It doesn't, if you don't write anything about it, and the sale price is 300,000 and it appraises for 299,000, this contract says the seller can just walk away. Okay, they don't have to negotiate. They don't have to come up with any money. The seller can't force them to accept the sale price of 299 if they're willing to drop it. Okay, but just like in a conventional contract, you can go back and negotiate that up front and say, okay, we've eliminated that, and we agree that if the sale price comes in $5,000 less, that the purchaser will cover that difference, something like it, just like on a conventional loan. So just keep in mind, if that puts you in a disadvantageous, is that a word?
Disadvantage?
Yeah.
No, no, I don't think so.
Oh, that might be.
Put a person at a disadvantage.
Okay, yeah, we'll rephrase it. I'm gonna look that up though, because if not, I'm gonna get that in there.
It'd be a good
It's a new
spelling
word.
word.
Yeah, that's a good. So anyway, if that's going to put them in a bad position from a negotiating standpoint, a competitive standpoint, then you might want to negotiate that kind of stuff, because as we pointed out before, if you're going out there against a conventional loan where somebody's putting 20% down, and you've got a VA loan or an FHA loan with 3.5% down or 0% down in the case of VA, yours is going to be looked at as not as a strong offer as the conventional, which by the way is total horse crap, because many of my VA borrowers are way more qualified than somebody putting 20 or 30% down on a conventional loan that are barely qualifying and may have lower credit scores. The difference to me is in the appraisal. Whereas if you're doing an FHA loan and the appraiser goes out there and there's some cracked or peeling paint on the side of one portion of the house, then they're going to mark it, and it's going to be required to be fixed, as Michael said, before closing. There's no negotiating around it and say, okay, well, we'll give you a credit towards closing costs or something like that. So that would be the thing that the sellers balk at, I think, more than anything. But don't presume that just because somebody's getting an FHA loan or VA loan that they're not qualified. This is something that you should keep in mind when you're dealing with your sellers more than anything. Okay, there's a lot of misinformation about that. I had an agent, not last year, but the year before, when I was still doing lunch and learns, a different company says, I don't like to do VA loans because the loan amounts are so low, or which is totally false. You know, VA loan, you could do a $750,000 loan, 100% financing, and you could never do that on a conventional loan. So it's just a great option for veterans. The other thing is to think that impose your personal opinions on financing. I've had an agent say, you know, well, if they can't get 20% down, then they shouldn't be buying a house. Who are you to say that? I mean, really? I mean, you know, get out of the business, because by the way, the average down payment is not 20% on any financing whatsoever. It's more like 12. So keep those things in mind. This paragraph 6C, where it says purchaser obtaining FHA financing, acknowledge the loan amount may be approximate because finance acquisition costs cannot be determined until settlement. Hello, this is 2021. This paragraph is from like 1995. I don't understand what this is whatsoever. There was a time when FHA loan amount calculations were based on closing costs. It was a convoluted formula. So if your closing costs were $5,000, there was you've got to borrow a certain percentage of the first 50,000 and then a certain percentage of the excess above that. And it was just crazy. Well, that doesn't happen anymore. So I don't even know what this means, but FHA down payment minimum is 3.5%, period. It doesn't matter if your closing costs are $3,000 or $15,000. It's going to be the same down payment. Another thing regarding contribution, I talked about points and stuff like that. One thing to point out
Paragraph 6 and 7.
in financing, just in general, is the seller can pay closing costs. There are limitations to it. Okay, so FHA, the seller can pay 6% of the sale price in closing costs for borrower. Rarely is it going to be that much. Okay, maybe if it's a very small loan amount. VA is super lenient. They'll allow you to pay all the closing costs, okay, plus an additional 4% of the sale price towards concessions. Okay, so for instance, suppose my clients have a judgment that needs paid off prior to closing and they don't have the money. Okay, VA will allow the seller to pay that for them, which is just crazy. No other loan program will let you do something like that. So just keep that in mind. That's not something you'll really get involved in unless we're writing a contract and saying, okay, we need X amount of dollars to go towards this kind of stuff. As far as required things that the seller would have to pay, the only thing to really keep in mind there, aside from stuff like grantor's tax, is VA does not allow the seller to pay for the termite inspection. Okay, so if you're negotiating a contract and it's VA and the seller says, well, look, I'm not paying for any of that kind of stuff, the answer is you have to. There's no around it. You negotiate it, including the sale price, whatever, but they've got to pay for the term.
What about well and septic?
Well and septic, either can pay.
Either can pay.
Yeah.
And folks, that's important because with the new septic addendum, which we'll get to later, the buyer has the right to do an expanded septic inspection with, digging up the box, doing the cameras, those kind of things, but it's at the buyer's expense.
Yeah, and we'll talk about well and septic a little bit more when we actually get to those paragraphs. So I think that's about all I have for paragraphs 6 and 7, loan fees, unless somebody has a question specific.
Yeah, any questions?
We good? All right, rotate.
Slowly, slowly, slowly. Okay, so then we get into title insurance, paragraph 8. Really, really important. In this one, you know how I talk about reading this and then putting it in your own terms? Well, what you do with this one is you read this, and in the column under own terms, you say, you need to get it. I mean, that's the bottom line, that you want the buyer to get title insurance. And again, Jay can confirm this, but the owner's going to, the lender's going to require it. There's what's called lender's title insurance. And what owner's title insurance is above and beyond the lender. So again, using the example we're using right now, 100% financing, you say, well, why do I need title insurance? Well, because the lender is requiring it, and he's going to, it's going to be on the loan amount. Loan amount's the same as the sales price. Well, the way things are going, if things appreciate by 5 or 6% a year over a 10-year period, your equity goes up. You've got a higher number, and with what you're paying on the mortgage, your loan amount's going down, and so your price goes up, your loan amount goes down. So now you've got equity, and you want to make sure that you protect your equity. So when it comes to title insurance, it's just like any other kind of insurance. If you never use it, it's a waste of money. But all you got to do is run into a situation where you didn't get it, and you now have some sort of claim, and the cost of that is something. Why didn't I listen to an agent? So first, before I would just read the paragraph. 1, you need to get it. 2, if you're not going to get it, or if you're thinking you don't need to get it, I need you to call Bill Tucker, who's handling this closing, or Chip Roy, or Charlottesville Settlement, or whoever it is, and have them explain to you what this means for you. And if you still decide you don't want to do it, then that's fine. But I'm telling you that there are just too many examples and stories of folks who either were grateful they had it or really bummed out that they did. And I'll give you a great example that's going on right now. Down the street from me, in another neighborhood, but a street that I drive through, the neighbor just cut down some trees. And they cut down the trees with their best intent. They were beginning to die. They were afraid that they're going to fall over, and they really thought that they might fall over on, the other person's house. And they did it, and one of the trees wasn't on their property. So now you've got a situation where somebody's, claiming that no, it was on my side of the property line, and whatever. That could become a title insurance issue. Another example would be you're putting in a fence, and you have the fence people come in and they put the fence around your property, and you find out you're 6 inches on somebody else's property. You go to that person who didn't realize that it was 6 inches on their property. When they sell their house and they go to do, the purchaser, gets a survey and finds out that the fence encroaches on their property. The seller may have an issue. The buyer says, no, I want this. I want all those 6 inches down the left side of my property. That's 6 more inches, whatever. And the buyer could cause the seller to have to move that. Well, if you have title insurance, those are the types of things that will protect you in that situation. And so it's kind of like the deed of trust, as I talked about early on in our discussions. The deed of trust is pages and pages of stuff, but it boils down to if you pay, you stay. If you don't, you won't, right? If you make your payments on a regular basis, no problems. But if you don't, then the deed of trust kicks in and tells you what's going to happen if you don't make those payments. And ultimately, it means you're going to be leaving that house. But as far as title insurance, purchaser's expense, purchase owner's title insurance, depending on the particular circumstances of the transaction, such insurance could affirm affirmative coverage against possible mechanics and material men's liens. What that is, mechanics and material men's liens, they had work done on the house prior to closing, and they didn't pay them. Well, that vendor, that contractor, whoever, has the right to file a claim against the property and gets put on the into the land records. And you could be, when you go to sell the house, you could be responsible for having to get that taken care of before you can sell the house. Title insurance protects you in that kind of situation. Though not recorded, blah, 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 could be subsequently recorded and would adversely affect purchaser's title of the property. Coverage afforded by such title insurance would be governed by the terms and conditions thereof, and the premium for attaining such title insurance coverage will be determined by its coverage. Purchaser may purchase title insurance at either standard or enhanced coverage and rates. Standard, it is, again, basic rate. Enhanced, a little bit above and beyond. And normally, don't quote me on this, but things that might be an enhanced is, I think the standard protects you, I want to say it's 150% of your sales price. So if you bought a house at 300 and your equity gets to 450, yeah, 450, that's 50% more. I think your coverage covers you up to that. Enhanced, I think involves a more extensive title search and the coverage of your own equity. But then again, that's why you want to get with Bill Tucker, Hope Payne, Chip Royer, Charlottesville Settlement, whoever it is, and have them explain to the buyers what the different options are. I just personally think it's one of those things that you want to pay, and yeah, it's a lot of money, but it's not that much money, because when you think about the fact that you have to pay the lenders anyway, it's required. There's nothing you can do about that. The owner's and enhanced, the owner standard and enhanced is above and beyond the lender one. So it's some of it you're already paying anyway. So when you look at it that way, maybe it doesn't quite feel as bad. For purpose of owner's policy, premium rate disclosure by purchasers lenders. If any, purchaser and seller require that enhanced rates be quoted by purchasers lenders. Purchaser understands that nothing herein obligates purchaser to obtain any owner's title and coverage at any time, included at settlement, and that availability of enhanced coverage is subject to underwriting criteria. So you're not required to get it. I'm just telling you that you want to get it. And I think whoever is representing your buyer, whether it's a settlement company or attorney, they're going to say the same thing. Questions about any of that? All right. Now we get into a little bit more of the fun part. as it relates to settlement and possession. The biggest difference in our contract or in the Virginia Realtor contract, as it relates to settlement and possession, is it says right underneath settlement, the words, and underline this, on or about. On or about. Remember, we talked about always trying to stay out of the gray. You know, we want to stay in the black and white. We want to know exactly what this or that means and what will happen if this or that happens. On or about does not answer that question. You know, Billy might think on or about is 3 days. Janine might think it's 8 days. Griffin may mean no, it's, you know, it's the date that's in here. Mark may say whatever. We all have an opinion. And guess what? All attorneys and closing companies have opinions as well. And so on or about means just that it's going to close. Let's say today is the 22nd of September, and miraculously, let's say you're going to close on November 3rd. On or about November 3rd. Settlement means that the time when the settlement agent has received the duly executed deed, loan funds, loan documents, and other documents and funds required to carry out the terms of this contract between the parties, and the settlement agent reasonably determines the precordation conditions of such contracts have been satisfied. Now, what does that mean? Well, one, we're going to settle on November 3rd, on or about November 3rd. Let's just say for the sake of discussion, we settled on November 3rd. I don't even know what kind of day that is. Hopefully it's in the middle of the week, and so there's no problem. Here's the other thing, just for you guys, remember this. Do not try to close at the end of the month, especially if it's a Friday. You know, you want to make sure your client gets the best service possible. And yes, at the end of the month is the best time to close because you pay your interest in arrears. And so you almost feel like you get a month free in the house because you're not going to pay them. If you settle on October 31st, you're not going to make a payment till December 1st. But the problem is so many people just auto default to October 30th or October 31st. Just remember this, write it in the line, whatever. Keep it near the end of the month, but make it the 27th or the 28th or, you know, a Wednesday. You don't want to close on a Friday. Quite honestly, you really don't want to close on a Thursday if you can help it. Monday, Tuesday, Wednesday, because what you want to do is make sure that everything goes well so that you're not sitting there on a Friday and everything didn't go well and you've got the truck packed and no place to, you know, take the truck. And so first, try to stay away from the end of the month. Definitely stay away from the end of the last Friday of the month. Try to keep it to a Wednesday or Thursday because that's going to give you the best chance of getting really good service, not quite as busy. And again, this is where that on or about comes in. It gives you a little bit of flexibility if something goes from one day to the next. That's why I'm even nervous about Thursdays, because if it rolls over a day and you get to Friday and you don't get everything done, it may be Monday because of the weekend. The good news is the contract changed with this most recent update, and it changed with the line I just read to you. Settlement means, and what that did is it pretty much in Charlottesville, which wasn't the case before, pretty much in Charlottesville, when you do the things that it says here, right? We executed the deed, the loan funds, the loan documents, other documents and funds required to carry out have all come in between the parties, and the settlement agent, lawyers, closing company, whatever, reasonably determines the precordation conditions of such contract have been satisfied. The key here is that you get the keys. You know, some attorneys wouldn't give you the keys until actually it has recorded. And that could cause a problem, because if you closed on a Friday morning, and if for whatever reason they didn't get it over there and get it recorded, some attorneys wouldn't let you have those keys until Monday. So this language was just recently added, and we've had conversations with the real estate attorneys and closing companies here in Charlottesville. And I think for the most part, people are now giving the keys at settlement, unless there's some, issue. So that's good news. Possession of the property, which includes transfer of keys to purchaser, shall occur at settlement unless otherwise agreed in writing by the parties. Now, what would that mean? Well, it could mean that the seller is going to stay in the property, what's called post-occupancy agreement. again, be very careful that you understand what you're doing when you either pre-occupy a property for the buyer or post-occupy a property for the seller. It sounds like it's a simple thing, but it's not, because the seller doesn't own the property anymore. You do. And therefore, the seller is gonna, you're gonna go do your walkthrough and everything, and you want to make sure that you've got in your post occupancy agreement that it talks about the fact if anything breaks at the time while the seller is still in it, even though that buyer owns it, that the seller is still responsible. The other thing is you want to make sure that the post occupancy agreement is closed-ended versus open-ended. I talked about this, I think, last Thursday, where we had a situation where a property closed and they did a post occupancy agreement and they upped the monthly rent if they stayed longer than that. And it turns out that the new home that the people are building still isn't done. And they're saying, sure, I'll pay that. Instead of having to try to find something else and make 2 moves and whatever, I'll pay that additional money. Well, that's not what was intended. What you want to do is, okay, we're going to post occupy and you're going to pay me this amount through September 30th. And then if we extend, it's going to go up by this much, but you will be out of that house by November 1st. You've got a no later than date in there. Don't leave it open-ended, in that situation. And quite honestly, on the pre-occupancy, if you've got a situation where somebody's wanting to pre-occupy the property, please see me before you do that, because you want to make sure that is just as tightly written as possible, because you could be in a situation where the people are in the house now, and so they lose some of their motivation for doing the things they need to do, to get to closing. And God forbid that something happens and all of a sudden they can't finance, they can't close, and now you got them in there and you got to figure out how to get them out of there. At settlement, seller will deliver the deed described in paragraph 15, an affidavit acceptable to purchaser and purchaser's title insurance company. There you go. See, you're going to convey a deed. That deed says that we in fact own the property. Another thing that title insurance protects against is any sort of fraud where the house may have been sold by somebody who didn't have any right to sell it. The example that I know of in a couple situations is it was sold as husband and wife, and the husband's girlfriend signed for the wife. The wife, was a divorce or separation or whatever, and the person sold it without the wife knowing about it. Obviously that's fraud, and that's a problem. But the point being is the people that got caught up in that, having the title insurance, all they do is they contact the title insurance carrier. The attorney takes over, and it's a hassle, but you're not paying for the hassle. It's really a hassle when you have to pay for the hassle. So you're going to deliver the deed described in paragraph 15, which obviously we'll get to. An affidavit acceptable to purchaser and purchaser's title insurance company as to parties in possession and mechanics liens, applicable non-foreign status and state residency certificates, and applicable IRS 1099 certificates. Janine, this is a great paragraph for our conversation yesterday as to why we wanted to talk to an attorney when it talked about applicable non-foreign status and state residency certificates, because you want to make sure if somebody's buying something who's a foreign national, that they understand that, yes, they might be able to buy this, but when they sell it, there are going to be some conditions that they're going to have to, jump through, including in most situations, some of the money being held until they can verify that taxes have been paid or whatever taxes need to be paid. So if somebody really does want to close on November 3rd, you need to cross out that on or about, and you need to put settlement shall be made at, on or at blank, which is the whatever company or attorney you're using. And instead of on or about, you put at blank on, and you cross out or about on November 3rd. And you could even, to make it even firmer, you would put in time is of the essence. And time is of the essence means November 3rd is November 3rd, unless everybody mutually agrees November 3rd is November 3rd. You can put TBD in for settlement shall be made at. If your purchaser doesn't know who they're going to use yet, You can put TBD as far as to be determined. I would encourage you, and I'm pretty sure they're in the Dropbox, the company Dropbox, and maybe the Agent Hub. Which, by the way, you guys are on the screen, you know that Vincent just changed the Agent Hub, and we'll be talking more about why he did that. We came across something that we can do sort of on our own from a local standpoint, and so we've added it in there. But the point being is that I just lost my train of thought. What was it?
You were talking about TBD.
Oh, right, thank you. So that in the Agent Hub or just in the office, I would grab one of the packages that has all the information about the Ednam Title joint venture that we have. That explains the joint venture. When you use one of the preferred attorneys, there's a guaranteed 10% discount on the title insurance and binder. Sometimes it's more than that because Katie knows that she's competing with other companies or whatever. But the other reason is on the back of that has a list of all of our preferred attorneys and the closing companies. So you can give that to the buyer when you're in the process of writing a contract and say, hey, these are our preferred attorneys. I've used these people, blah, blah, or I've heard these, blah, blah. But if you want to call a few of these folks and see who you want to use and then let me know, that would be great. It's a good list of qualified attorneys and closing companies here in the area. All right, questions on any of that? Go ahead. Yeah.
Back to me. All right, a couple things. Probably the most important thing is I want to point out that disadvantageous is actually a word.
Oh, there you go. Hey, I'm
Okay.
just a PE major. What do I do?
All right. Well, it just sounded like a mouthful, so I wasn't sure. It's like, well, that was a lot of syllables there.
Yeah.
Okay. First of all, per diem interest as it relates to closing date. The advantage to closing at the end of the month is that you can walk into closing with less cash. It is not, don't interpret this as a savings of money. Okay. For instance, if I close on September 30th, I'm going to pay 1 day of interest on that new loan. And my first payment is going to be basically a month away on November 1. Okay. So the mortgage payment is always after the first full month of interest accrues. Okay. Now, if I close on September 1st, I'm going to pay 30 days of interest at closing, but my first payment is still going to be December 1st. Okay. So pay a full month of interest, first mortgage payment 60 days away. Pay 1 day of interest, first payment 30 days away. Okay. The money is certainly less at closing at the end of the month, but don't make sure that people understand that they're not saving money by doing that. And that could become important if you're trying to squeeze in the end of the month, because that's when everybody is super busy. Okay. If you're talking about a seller rent back, okay, keep this date in mind, 60 days. Okay.
Yeah.
It affects the financing. If my client is buying a house as their primary residence and there's a seller lease back for 90 days, that is not a primary residence anymore in the lender's eyes. It's a rental property, and that's going to change their down payment requirement, and it's going to jack up their interest rate badly. Okay. So just keep in mind, it's 60 days and not 2 months. Okay. 60 calendar days. Make sure that that ends at that time, and make sure that if that's something like that's occurring, that the lender knows that that's occurring. There's nothing worse, and I've had it happen to me, where we get to closing and on the CD there's a credit from the seller for rent back, and then I find out that the rent back's for 90 days. Like, well, now we've got to change everything. We've got to change that lease back agreement because we certainly don't want to change the financing. So just sort of keep those things in mind. Key point, 60 days. By the way, some lenders will have what we call an overlay, which is a more restrictive requirement, which says that the lease back can't be more than 30 days. So make sure you're aware of what the requirements are. That's all.
Awesome. Thank you.
Yeah, really good points. All right. We're gonna get through paragraph 10. And we might get through paragraph 11, but this is a really important one, especially right now. Expenses, prorations, and rollback taxes. I need to be cognizant of time because I know that Ben's teaching at 10:30. But each party shall bear its own expenses in connection with its contract. There's some things in here that you just want to make sure you understand and underline, except as specifically provided otherwise herein. Seller agrees to pay the expense of preparing the deed, recordation tax applicable to grantors. So I talked about that earlier. All expenses incurred. Well, let me just say this real quick. Except as specifically provided otherwise herein, seller agrees to pay expense of preparing the deed and the recordation tax applicable to grantors taxes. If you're in a situation where you think you're in a multiple contract presentation and you're trying to win, one thing that you can do that I hadn't really thought about till I was talking a while back, and never thought about this before, but you can offer to pay the seller's grantor taxes, or you can agree to pay the seller's, closing costs, except for commission. Make sure you put that in there, because that'd be a significant payment. But it says agree, except as specifically provided otherwise herein. Well, if you put in purchaser agrees to pay the seller's closing costs as it relates to preparing the deed and recordation taxes to the state, that can be, hundreds of dollars that the buyer and seller now gains. And that if another buyer hasn't thought about adding that in there, that could be the difference between you winning and losing. So, just keep that in mind. And then, hang on a second. Yeah. And then purchaser in connection with the purchase, including without limitation, title examination, insurance premiums, survey costs, recording costs, and the fees of purchase attorney shall be borne by the purchaser. All right. So you've got title exam, you've got title binder, you got insurance premiums, your hazard insurance premium, home warranty insurance premium that you might be paying if you haven't gotten the seller to do it. If you've asked for a survey to be done, again, I think it's important. It's a cost, but I think it's important to get at least an aerial survey. There's what's called an aerial survey, and I think that's what it's called. And then you have a four-corner post survey. Four-corner post survey is much more expensive because you actually have people going out and putting the posts in the corners and shooting the lines, and you get an accurate. But they also now, because of GPS and everything, they can do these aerial surveys. Don't depend on a plat that they provide to you, the seller provides to you. I would, have something, if I'm going to get a plat and not get a survey that the seller's provided to me, look at the date on it. And let's just say, for the sake of discussion, the plat has, it's got the lot all laid out, but there's no fence. And now there is a fence. Well, that means that something's happened since that plat was done. And again, going back to what I said before, you want to make sure that, the storage shed that was built still is on the property, that kind of thing. And so if they're going to give you a plat, then I would have something that says that the seller substantiates that this plat is accurate. And if there's any, issues found in the title search, that the seller will bear the cost of fixing that. But anyway, and then in addition to the purchase price, and this is what's really important right now, purchaser agrees to pay seller for all fuel, underline this, all fuel, oil, and or propane remaining in the tank. This is something that people forget about. You've got an oil burning furnace. They may have 500 gallons of fuel in there. And I don't know what that costs right now, but it's $3 a gallon. I don't even know.
It could be a lot.
Yeah, so it could be $1,500 where the seller's looking for their money, because you've agreed in this paragraph, unless you change it, the purchaser agrees to pay for all fuel, oil, and or propane remaining in the tank. And there's some agents out there that recommend, like right now it's September, and they're putting their house in the market. The agents will say, fill up your oil tank and have an invoice, so that when we get a contract, we can provide this to them, that the oil tank has been filled. It's 500 gallons. It's this much, per gallon. And you've got verification there. But normally what will happen is that, before closing, the oil company that does it will come out. Usually it's free of service, and they'll measure and say, of the 500, there's 300 gallons left. 300 times 3 is $900 kind of thing. And then, so just underline that and remember that. And then the other one, which we're dealing with right now, to be perfectly honest, rollback taxes. Well, normally if you're in Forest Lakes, or Glenmore or Edmond Forest, whatever, you're not going to have rollback taxes. It's a subdivision and whatever. But if you're buying a piece of property that's been in a certain type of land use, and the buyer decides to take it out of that land use and do something else with it, the county has the right to come back and take taxes from up until when it comes out of land use to back. So they're what's called rollback taxes. Normally, you're going to see in here if the seller to pay any rollback taxes, if any. That's what you're writing in. So if you're representing the buyer, you're putting in and putting that on the seller, in the seller's lap. We have a situation right now where it was written in that way, and it got missed. And now the buyer is looking for the seller to pay the rollback taxes, and the agent involved communicated with the attorney like a week ahead of time saying, hey, we've got this situation. We've now learned that the buyer is thinking about taking it out of land use. We need to deal with this and get it resolved before closing. And neither of the attorneys did anything about it. And so now what we've got is a situation where there's rollback taxes due, and the seller's going, wait, I said that, I wasn't going to do that. If you're the one who's taking it out of land use, not me. And so now there's a fight, and I don't know how it's going to be resolved. So again, if you're representing a seller and you see that, and it says rollback taxes to be paid by seller, if any, make sure your seller understands what that means. Get with whoever they're going to use for the closing and say, hey, here's my situation. The property is in this land use right now. If the buyers buy this and take it out of that, am I going to be responsible? And if so, you're going to need to cross that out or work something out mutually agreeable. So there's a real live, situation happening right now, practical application as it relates to that paragraph. All right, I'm going to stop it. Go ahead, Jay.
Just a quick question. How do you know up front when you're writing a contract if there's going to be rollback taxes?
You don't. That's why people write
So
in.
this could be after the fact,
Right.
that they come back to the seller if it's written this way to say, oh, you owe us money now.
That's right.
Okay.
And the point of it is that the seller will know, and it's a great question. If you have number of acreage and you see, hay bales, or you see, llamas, or, whatever, that property is in some sort of land use. If that buyer comes and buys that house and decides to, and I'm just giving you an example. I don't know if this would pertain, but just as an example, they buy that property and it's got a division right on it. And so, they take the seller takes their llamas and leaves, or alpacas, or whatever they do, and leaves. And that buyer now takes it out of land use and has that house and decides to build another house on that other division right. Well, that's no longer going to be used for agricultural reasons. And that could kick in, the rollback tax situation. So that's why it's important where if you're listing a property that has, acreage and the seller's going to know, the seller's going to know that they've been getting tax benefit, from a scenario of that. So, okay. We made it through paragraph 10. We doubled our pleasure in 1 hour. So that's good. We're about a third of the way through. I'm going to cut us off at this particular point so that folks who want to join Ben Fuller here at Ednum for Engaged 2 can do that. And in the meantime, I hope you guys have a great day.
Thanks, Michael. See ya.
Yeah, my pleasure. Thank you,
Thanks,
guys.
Michael.
Fair enough. Mark, you haven't heard anything.